Mr. Chairman. Thank you, Secretary Rubio, for being here. On March 21st, 2025, the State Department approved the revocation of a student visa for Rumeysa Öztürk, a Turkish citizen who is a graduate student at Tufts University, apparently simply for writing an op-ed. According to an internal State Department memo, you took this action under your discretionary authority to revoke visas, and soon after you revoked her visa, armed and masked plainclothes officers snatched Ms. Öztürk off the street and transported her to a prison in Louisiana. Mr. Secretary, do you really think that Ms. Öztürk's op-ed results in a foreign policy consequence for the United States?
Rumeysa Öztürk's story begins with a simple yet powerful act, writing. As a Turkish graduate student studying at Tufts University in the United States, she engaged in a common academic exercise, expressing her opinion in a published article. For many students, especially those in a democratic society, participating in public discourse through writing is a rite of passage. It reflects critical thinking, civic awareness, and a willingness to participate in the marketplace of ideas. However, for Öztürk, this expression did not lead to academic debate or constructive dialogue. Instead, it marked the beginning of a legal and political nightmare. On March 21, 2025, the U.S. State Department revoked her student visa, and the only cited reason behind the action was the fact that she had co-authored an op-ed in the university's newspaper. This sudden action not only threatened her academic future, but also questioned the very values of free expression that America often champions globally. The revocation of her visa was done quietly, under the discretionary authority of the Secretary of State, Marco Rubio. No formal warning was issued. No opportunity was given to Öztürk to defend her position or explain her intentions behind the article. This left many questioning the transparency and fairness of the decision. Visa revocations are not uncommon, but the lack of due process in this case added to the public outrage. The content of the op-ed was not inciting violence, promoting terrorism, or spreading hate speech. Rather, it reportedly offered critical viewpoints about U.S. foreign policy. In a university setting, especially in graduate-level discourse, such opinions are not only expected but encouraged. Academia thrives on debate, diverse perspectives, and open conversations. That a student would face such severe consequences for an opinion piece seemed not only disproportionate but deeply disturbing to those who value academic freedom. What made the situation more troubling was the fact that the action against Öztürk was not isolated to paperwork or immigration status. Following the visa revocation, she was physically removed from public space by armed and masked individuals. The very idea that a graduate student could be apprehended in such a militarized manner, without being charged with a crime, sparked widespread concern. People asked, how could this happen in a country that upholds the rule of law and civil liberties? Legal experts and civil rights advocates immediately began scrutinizing the details of the case. Questions arose regarding the balance between national security authority and individual rights, especially the rights of foreign nationals residing in the U.S. For academic purposes, according to public records and an internal State Department memo, there was no concrete evidence to suggest that Öztürk was involved in any criminal or dangerous activity. The memo made it clear that the primary justification for the revocation was her written opinion. This put the entire incident into a different light. It wasn't about threats, security concerns, or violations of immigration law. It was about controlling speech. The implication that the U.S. government, particularly the Secretary of State, could use visa revocation as a tool to suppress dissenting voices sent a chilling message to international students and immigrants across the country. The incident also raised questions about the criteria used for revoking student visas. If the mere act of writing critically about the government can be deemed grounds for deportation or arrest, then what protections remain for foreign students who came to the U.S. under the promise of intellectual freedom and democratic values? Rumeysa Öztürk's case created an atmosphere of fear and uncertainty within academic circles. International students began to wonder if their research topics, publications, or classroom discussions could place them under surveillance or at risk of punishment. Faculty members expressed concern that the precedent set by this case could undermine the university's mission of fostering open and honest dialogue. Furthermore, the political dimensions of the case couldn't be ignored. Secretary Rubio's stance that there is no constitutional right to a student visa was legally accurate, but it missed the broader point. The issue was not whether someone is entitled to a visa, but whether the government can punish speech by revoking that visa. Osterk's case blurred the line between legal immigration authority and political retaliation. If visa revocations become a way to silence voices that challenge governmental decisions, the long-standing tradition of academic freedom is seriously endangered. Media coverage of the incident added to the controversy. Prominent newspapers and commentators highlighted how Osterk's case symbolized a shift in U.S. policy, one where dissent was not debated but erased. Public opinion was divided. While some supported the government's decision, citing national security concerns, many others felt that the decision was arbitrary, unjust, and in violation of American principles. Social media platforms erupted with hashtags and campaigns calling for Osterk's release and criticizing the administration's heavy-handed approach. Her arrest also sparked protests on university campuses. Students and faculty organized rallies, wrote letters to government officials, and demanded explanations. They argued that silencing students through deportation or detention sends the wrong message about what America represents. They pointed out that if this could happen to Osterk, it could happen to anyone. The story transcended academic borders and entered the broader political dialogue about immigration, freedom, and power. It wasn't long before lawmakers began weighing in. Congressional hearings were held, and the matter was discussed openly in committee rooms. The lack of due process, the aggressive nature of the arrest, and the implications for free speech all became focal points of concern. Some members of Congress demanded accountability from Secretary Rubio, while others supported his decision. The debate highlighted a growing tension in American politics between those who prioritize security above all else and those who view liberty and constitutional protections as non-negotiable. Eventually, the matter reached the courts. A federal judge reviewed the case and ordered Osterk's release. The ruling was clear. The government had failed to provide sufficient legal grounds for her detention. The court's decision reinforced the principle that even non-citizens have basic rights when they are in the United States. It affirmed that expressing a controversial opinion does not constitute a crime, and it cannot be the sole basis for imprisonment. But the damage had been done. Romia Osterk spent days in detention, isolated and cut off from legal support, all because she dared to write. Her story became a cautionary tale for thousands of international students. Her experience shed light on how fragile freedom can become when political interests and unchecked authority take precedence over justice. In the end, Osterk's case is more than just a headline. It is a mirror reflecting the state of American democracy and how it treats the most vulnerable among us. It forces a necessary conversation about whether the U.S. can remain a beacon of freedom if it begins to punish people not for what they do, but for what they say.
That case involves someone whose visa we never would have granted had we known ahead of time.
I'm not asking you that question. I'm asking you if
telling
you
you,
think
would
an
we-
op-ed, if an op-ed,
not an
which,
op-ed.
but that's exactly, in fact, what happened. The State Department wrote a memo concluding that you did not have sufficient grounds to revoke Ms. Osterk's visa. There was no evidence showing that she'd engaged in any activities that were a threat to national security. And in fact, in May, a federal court ordered Ms. Osterk's release from detention, noting that the sole basis for the government's detention appeared to be the fact that she co-authored this opinion piece in the Tufts newspaper in March of 2024. Where in the Constitution does it say that the Secretary of State can override the First Amendment protections of free speech. Is there a
Constitution-
footnote that I missed
There's
somewhere?
no constitutional right to a student visa.
So, but is there
Student visa is a
a
privilege.
constitutional right? Does it say somewhere that Marco Rubio gets to determine which speech is appropriate and revoke student visas based on what you think constitutes free speech?
There's a statute that says the Secretary of State gets to determine whether someone is a threat. We deny visas every day all over the world. And we'll
Do you think that the Immigration and Nationality Act trumps the Constitution of the United States, Mr. Secretary?
Well, Congress.
In the aftermath of Romea Osterk's arrest and visa revocation, the legal battle over her detention became a defining moment in the national conversation about free speech, immigration policy, and due process. When a federal court intervened and ordered her release, it was not just a procedural correction. It was a strong, clear message that the United States government had crossed a line. The court found that there were no valid legal grounds for detaining Osterk. According to the ruling, the only basis the government had presented for her arrest and continued detention was the fact that she had co-authored an opinion article, a piece of writing that fell squarely under the protections of free expression. This ruling was monumental. In a time when immigration enforcement has often existed in a gray area of unchecked authority and executive discretion, a federal judge reminded the nation that the rule of law still applies, even to non-citizens. The Constitution, particularly its protection of free speech under the First Amendment, is not confined to citizens alone. It governs how power must be exercised within the borders of the United States. The court's decision underscored that no government agency, not even the State Department or the Secretary of State, has the power to detain someone arbitrarily based on the content of their thoughts or written words. The judge's decision to release Osterk also acknowledged the complete lack of evidence suggesting she posed any threat to national security, which had been the official justification for revoking her visa and detaining her. This revelation was damning. It exposed a troubling use of governmental power, one that appeared less concerned with legitimate security threats and more interested in silencing voices of dissent or critique. The fact that the court had to step in at all suggested that the system had failed at multiple points before the matter reached the judiciary. Immigration authorities, law enforcement, and State Department officials all participated in a process that treated free expression as a punishable offense. One of the most unsettling aspects of the case was how quickly and easily Osterk was stripped of her basic rights. Within hours of her visa being revoked, she was taken from the street by masked, armed officers who did not identify themselves. She was not read her rights, given access to legal counsel, or informed of the charges against her, because, in truth, there were none. This kind of extrajudicial action is usually associated with authoritarian regimes, not with a democratic country that prides itself on transparency and the rule of law. That it happened in the United States, and to a peaceful student whose only offense was writing, sent shockwaves through the legal and academic communities. The federal court's ruling also had a ripple effect. It forced a public reevaluation of the limits of executive power in immigration matters. Yes, the government has broad discretion to grant or deny visas, but that discretion does not extend to detaining people without cause or punishing individuals for engaging in constitutionally protected activities. The decision set a precedent. Writing an article, no matter how controversial, cannot legally be equated with criminal or subversive activity unless there is tangible evidence to suggest otherwise. Legal scholars quickly weighed in on the implications of the court's decision. Many noted that this was a rare but powerful judicial rebuke of executive overreach. Immigration law, historically, has allowed significant latitude for the government, but the court made clear that even in these areas of broad authority, there are boundaries that must not be crossed. When those boundaries are crossed, it is the judiciary's responsibility to intervene, restore justice, and reinforce the rule of law. The ruling also prompted renewed discussions around the treatment of international students in the United States. If a student can be imprisoned for writing, what protections do others have? Should students censor their academic opinions to avoid government scrutiny? These questions became common in classrooms, forums, and university panels nationwide, professors expressed concern that cases like Osterk's could have a chilling effect on academic freedom. Institutions of higher learning, which depend on the free exchange of ideas, were now under pressure to reassure students that their voices were safe, and that the values of scholarship and critical thinking would not be undermined by political agendas. Rubio Osterk's case also raised the issue of selective enforcement. The government had justified its actions by invoking national security, yet it presented no evidence of danger. Meanwhile, individuals who had expressed actual hate speech or inflammatory views were not subjected to the same treatment. This inconsistency made the government's position even more suspect. Why was Osterk targeted? Was it because she was foreign, because her opinion challenged U.S. policy, or because she was seen as an easy target? These were the uncomfortable questions that emerged in the wake of the court's ruling. The judicial order for her release did not simply mark the end of her detention. It opened a broader inquiry into how laws were being applied and whether the motives behind enforcement actions were grounded in principle or politics. Advocacy groups and civil liberties organizations seized on the court's decision as evidence that stronger safeguards were needed to protect foreign nationals, especially students, from arbitrary state action. Legal petitions, op-eds, and public campaigns followed, urging Congress to review the powers granted to immigration and security agencies under current laws. Additionally, the court's ruling placed significant pressure on the Secretary of State and his office to provide clearer guidelines about the visa revocation process. If a student's visa can be revoked based on content alone, where does it stop? Would future students be penalized for classroom presentations, social media posts, or even private conversations? The absence of a clear standard posed serious risks to civil liberties and invited accusations of discrimination and abuse of power. Rubio Osterk's experience and the court's intervention that freed her serve as a case study in the tension between national security concerns and constitutional rights. It was a stark reminder that the balance between the two must be carefully managed, and that when it tips too far in favor of authority, justice demands correction. The legal system functioned as a check on power in this instance, but many wondered, what would have happened if Osterk hadn't had legal representation? What if her case had never gained media attention? Would she still be in detention? These questions illustrate the fragility of rights when they rely on awareness and activism to be upheld. Not everyone has access to legal teams or public platforms. Therefore, the court's decision was not just about Rubio. It was about affirming the principle that speech, no matter how unpopular or critical, cannot be criminalized in a free society. It was a victory for the Constitution, for the rule of law, and for every person, citizen or not, who believes that ideas must be debated, not silenced. In the end, the federal court did what the system is supposed to do. It corrected an injustice. It reaffirmed that in America, speech is not a crime and writing is not an act of war. It protected a student whose only weapon was her pen and whose only offense was her voice. And in doing so, it reminded the world that even when power overreaches, the law can still serve as a shield for the voiceless. The case of Rubio Osterk did not just raise legal questions. It ignited a constitutional firestorm over free speech, the role of government authority, and how America defines and upholds its foundational values. At the heart of this debate was the First Amendment of the United States Constitution, which guarantees the right to free speech, freedom of the press, the right to peacefully assemble, and the ability to petition the government for redress of grievances. These are not vague privileges. They are specific enshrined rights. And yet, in Osterk's case, those very protections were seemingly overridden by a political decision to revoke her visa based solely on an op-ed she co-authored, an action that deeply troubled lawmakers, legal experts, academics, and civil rights advocates alike. The fact that a student's opinion piece could trigger such a swift and severe response revealed a dangerous precedent. It suggested that government officials could now determine what constitutes acceptable speech, especially when it comes from foreign nationals. This idea is incompatible with the First Amendment, which does not carve out exceptions based on immigration status or political sensitivity. Once a person is on U.S. soil, even temporarily, they are afforded certain rights, particularly the right to free expression. That includes students, journalists, workers, and visitors alike. Romeo Osterk's case became a flashpoint because it raised the uncomfortable reality that constitutional rights can be bypassed through administrative discretion. While the government argued that visa holders are not guaranteed the same constitutional protections as citizens, the public and many lawmakers challenged that rationale. They emphasized that the First Amendment is not reserved only for Americans. It is a standard for how the U.S. government must treat anyone within its jurisdiction. If the government can target non-citizens for what they say, it creates a two-tiered system of rights, one where speech is protected only for some, but punishable for others. That's not just a slippery slope. It's a direct contradiction of the democratic ideals the country is built upon. Secretary Marco Rubio, in defending his actions, pointed to statutes and legal authority that allow the State Department to revoke visas at their discretion. But critics argued that discretion should not extend to punishing political views or expressions of dissent. If visa revocation becomes a tool to silence critics, the government essentially becomes an arbiter of truth, deciding who can speak and who cannot. That power is inherently dangerous and antithetical to the principle of open dialogue that is central to any free society. Members of Congress who raised concerns about Osterk's treatment did so not only because they believed the action was legally questionable, but because they feared its broader implications. They asked, if one student is removed for writing an article, what's to stop the government from targeting others? Perhaps professors, journalists, or public speakers, whose ideas are unpopular or inconvenient. Would international researchers now avoid politically sensitive topics for fear of retaliation? Would foreign students begin to self-censor, watering down their opinions in order to remain in the country? These are not paranoid hypotheticals. They are rational fears based on a real and recent event. Moreover, the government's decision to treat Osterk as a security threat simply because of a written opinion weakened its credibility. National security is a serious matter, and it should not be invoked lightly. By using it as justification in a case where no threat was present, officials diluted the meaning of the term and undermined future efforts to address legitimate risks. When security arguments are used to mask political motives, it not only endangers individual rights, but also erodes public trust in the institutions meant to protect the nation. The debate also drew attention to a wider concern, the growing power of executive agencies to act without accountability. Immigration law, in particular, grants vast authority to the executive branch. But unchecked power, no matter how well-intentioned, can easily be abused. Osterk's case revealed how such power can be exercised in ways that violate constitutional values. The decision to revoke her visa may have been legal under certain statutes, but it was arguably unconstitutional in its motivation and effect. That distinction is crucial. Just because something is technically legal does not mean it is just ethical or consistent with democratic principles. Universities, traditionally considered safe spaces for the exchange of ideas, were suddenly implicated in a broader struggle over free speech. Many academic institutions issued public statements condemning the visa revocation and expressing solidarity with Osterk. They emphasized that academic freedom must apply to all students, regardless of nationality. Without it, higher education loses its purpose to challenge, question, and explore. If students must worry about deportation for their opinions, then the classroom becomes a place of fear, not discovery. The First Amendment protects even the most controversial speech because democracy requires a robust and sometimes uncomfortable exchange of ideas. Suppressing unpopular opinions does not strengthen society. It weakens it by creating echo chambers and limiting the diversity of thought. Osterk's op-ed, though critical, was not inflammatory. It did not incite violence or promote hate. It simply offered a viewpoint. That viewpoint may have clashed with certain policies or ideologies, but in a democracy, disagreement is not a crime. Civil liberties organizations such as the ACLU weighed in strongly on the matter, arguing that Osterk's case could have far-reaching consequences. They warned that allowing the government to police speech through immigration enforcement would create a climate of fear for all non-citizens and set a precedent for censorship. If the government can punish you for speaking your mind, then freedom of speech becomes an illusion, dependent on approval rather than protected by law. The incident forced a deeper conversation about what it means to truly protect freedom of speech. It's easy to champion free expression when the speech is agreeable or supportive of prevailing norms. The real test comes when that speech is dissenting, uncomfortable, or provocative. Osterk's experience highlighted that the U.S. still struggles with protecting dissent, especially when it comes from those with less power, fewer rights, or foreign backgrounds. But those are exactly the voices that need protection most. Because once governments start determining who can speak based on content or identity, everyone's speech becomes vulnerable. In the wake of the case, calls for reform began to emerge. Legal scholars suggested new legislative safeguards to prevent the abuse of visa authority. Activists pushed for greater oversight of how immigration laws intersect with civil liberties, and many urged universities to be more vocal and protective of their international students, who often find themselves in precarious positions when political and legal interests collide. Ultimately, Rubio Osterk's story is not just about one student and one visa. It's about a clash of values, authority versus liberty, power versus rights, silence versus speech. The case demanded that the country look inward and ask difficult questions. Are we living up to our constitutional promises? Are we protecting the most fundamental freedoms for all who walk our streets, study in our classrooms, and participate in our public discourse? The answers will define not just immigration policy or campus culture, but the very soul of American democracy.